principle and unfolding the rule of law. I don't propose to make an introduction. I think the umbrella movement is familiar to all of us, and nor will I introduce the panel. I think they're sufficiently distinguished so that everyone knows who they are. What I propose to do is do what I'm supposed to do as moderator, which is keep strict time. My instructions are to keep time ruthlessly. The panelists will each speak for 10 minutes, and no more than 10 minutes. And then after that, so that will take 50 minutes in all, after that, I'll open the floor to questions and answers. The questions, answers, may be in English, Cantonese. I would also suggest Putonghua. I would invite whoever from the floor asks a question, makes a comment, to be brief, succinct, to the point. I will be equally ruthless if the person from the floor is long-winded and not to the point. I will simply cut you off. So we will start now with Albert Chen, who will speak on the Standing Committee of the NPC's decision. Albert.
Thank you, Mr. Chairman. The NPC Standing Committee's decision at the end of August this year is probably the most controversial legal or constitutional event in Hong Kong since the 1997 handover. As we all know, the basic law provides for the political system of the Hong Kong SAR, and it provides for a logic of evolution of that system towards universal suffrage in both the election of the chief executive and all the members of the Legislative Council. In the year 2004, because of a democracy movement at the time, following the failure of the national security legislation on Article 23 of the Basic Law, the NPC Standing Committee rendered a very important interpretation of the Basic Law, which sets out a 5-step procedure for political reform in Hong Kong. According to this 5-step procedure, the first step, in the case of any proposed reform of the electoral system for the chief executive and electoral, the first step would be for the chief executive to submit a report to the NPC Standing Committee. And the second step is for the Standing Committee to make a decision on the report. Then, on the basis of the Standing Committee's decision, the third step would be for the chief executive and the HKSL government to submit a political reform package to the Legislative Council. Then it's up to the Legislative Council to decide whether to approve the package by 2/3 majority, in which case the CG can give his consent, and then the matter will be sent to the NPC Standing Committee for approval in the case of the reform to the election of the chief executive, and for the record in the case of Legislative Council electoral reform. This 5-step procedure has been invoked 3 times so far since 2004. The Standing Committee has made 3 decisions, one in 2004, the other in 2007, and most recently in August this year. Each decision is about whether there can be political reform in the foreseeable future, and also the parameters or conditions for the reform. That is, under what conditions can the reform go ahead, or what will be the basic elements of the reform. Among these 3 decisions, as we know, the latest decision is the most controversial because it actually stipulates what some people regard as the end point of Hong Kong's political evolution as far as the election of the chief executive is concerned. The Basic Law provides for the ultimate goal of election of the chief executive by universal suffrage, and this decision stipulates the model for implementing such universal suffrage. In particular, how the nominating committee, as provided for in the Basic Law, would would do its work of making nominations of candidates. I think in order to understand the Standing Committee's decision, we need to take into account all the speeches which have been made by mainland Chinese officials since spring last year. And you remember that in March 2013, Mr. Chao Xiaoyang, speaking in Shenzhen to the so-called pro-establishment legislators, announced certain basic principles regarding the design of the electoral system for the chief executive. Basically, the chief executive must be a patriot, somebody who loves Hong Kong and the motherland, and cannot be somebody who is confrontational towards the mainland government. Subsequently, the expression, the sovereignty, security, and developmental interests of the PRC has been often used when discussing this issue of universal suffrage, saying that any model for universal suffrage in Hong Kong must be consistent with the sovereignty, security, and developmental interests of the People's Republic of China. I will not have time to tell you about the exact details of the Standing Committee decision, but I would like to draw attention to some of the main points regarding the rationale of the decision, which are partly in the decision itself and partly in the speeches of officials like Li Fei, who visited Hong Kong immediately after the decision was rendered. If we look at the decision itself, it emphasizes that the chief executive of the HKSR shall be accountable to both the HKSR and the Central People's Government, and therefore the principle that the chief executive has to be a person who loves the country and loves Hong Kong must be upheld. This is expressly stated in the decision. It is also stated that the method for selecting the chief executive by universal suffrage must provide corresponding institutional safeguards for this purpose. When Mr. Li Fei visited Hong Kong subsequently, he also emphasized that the decision provides the institutional guarantee that the chief executive elected by universal suffrage in future will be someone who is both trusted by the central government and supported by the people of Hong Kong, and that non-patriots or those confrontational towards the central government could not become the chief executive. He pointed out that the question of the model for universal suffrage in Hong Kong involves, and I quote, a struggle for the power to govern the HKSAR, unquote. And he also said that, and I quote, if we understand the political nature of the question of universal suffrage, we see that the question involves matters of fundamental principles on which there can be no compromise. Those who insist in being confrontational towards the central government cannot be the chief executive, whether in the past, present, or future, unquote. Now I turn to the discussion about whether the decision can be changed. Given the detailed consideration which the central authorities have given to the matter, and the basic policy rationale behind the decision, it is extremely unlikely that the decision will be changed in the foreseeable future. But it doesn't mean that the decision or the nomination system prescribed in the decision can never change. I believe that if universal suffrage on the basis of this decision is introduced in the year 2017, which at the moment is quite unlikely because, as we all know, the pan-Democrats in Mexico are opposed to it and they have the veto power. But if the universal suffrage prescribed in the decision materializes for 2017, then we'll have a first trial of this electoral system. And on the basis of the experience gained at that time, I think it is perfectly possible that revisions to the nomination system can be considered and revised in the future for the next election in 2022. I also believe that the nomination system and its design is based partly on consideration regarding the relationship between Hong Kong and the mainland political system, the relationship between the pan-democrats, one of the two major political forces in Hong Kong, and the central authorities. And these relationships can change in the future. The decision is also partly based on considerations as to the requirements of political stability in mainland China and the maintenance of existing Communist Party-led political system. In case there are political reforms in mainland China in the future, it is also possible that the policy towards universal suffrage in Hong Kong or at least nomination system can be revised or reconsidered. There will be a second round of consultation to work on the details of the model for implementing universal suffrage. And since my 10 minutes has almost run out, I'll reserve my discussion or comments on the second round of consultation and the detailed electoral model for the Q&A period. Thank you.
Thank you very much, Albert. Johannes will now speak on civic nomination. Could I just say that there have been a number of mobile phones that have gone off. That should not happen. Let's take 1 second to turn off or put our mobile phones on silent mode now.
Thank you, Samuel. One of the bone of contentions in the current debate is civic nomination, as the protesters insist on civic nomination as part of their platform. So what I'm trying to do is to look at whether there is a legal basis for doing so, and in so doing, hopefully that would also unveil any rooms for further discussions to bring the two parties together. Albert has already set the scene. Article 45 is familiar to most of the people in Hong Kong now. And Article 35 refers to quite a number of aspects there. There is the selection of the chief executive by universal suffrage, and then there's a nomination by a broadly representative nomination committee and democratic procedure. And under this article, the question asks, is there room for civic nomination? The first part, which we have discussed quite a bit already in Hong Kong, is a broadly representative nomination committee, and the MPC Standing Committee decision is that it has to model after the 2012 election committee. And the 2012 election committee has 1,200 members coming from 4 sectors. And these 4 sectors are further subdivided. Apart from the 4 sectors, who are the former political figures and current political figures, there are 96 people from these sectors who are ex officio. And if you exclude that 96 members, and there are another 60 members to be nominated by the religious sectors, basically we have 1,000 odd members, around 1,000 members from these 1,200 members who are to be returned by 38, from 38 subsectors there. And if we pause here, a quick glance at these 38 subsectors, one may not be entirely happy with them, but then one cannot say that the sector on the face of it are not representative. Whether they're sufficiently broad is another thing, but at least the sector itself seems to cover quite a wide range of people. The difficulty is who are the people who make up of the voters in these subsectors, and here lies the difficulties. And when people say that this election or nomination committee is not sufficiently representative, one really needs to go to the details there. And look at the fishing, agriculture and fishery, leaving aside that no matter in what way we look at it, why would it represent 60 members or return 60 members when even the financial sectors return only 18 members. But leaving that aside, look at some of the voters, there are altogether 80 voters in these subsectors, and it includes like Aberdeen Fishermen Friendship Association and Aberdeen Fisherwomen Association. With every respect for them, I'm not aware that the fishermen are the model who advocate gender equality. And then you have Hong Kong and Kowloon Fishermen Association and Hong Kong Fishermen Association, New Territories North District Fishermen's Association, Sai Kung Fishermen Association Limited. Now, just use your imagination and you can reproduce as many as you like. And for some of the sectors, they can subdivide into really very small subsectors there. And another example, the transport again, there are only 226, and by the way, both fishermen, agriculture, and transport have only natural voters or corporate voters. There's no natural persons at all. And out of these 226 corporate voters in the transport sectors, now you have Association of New Territories Radio Taxi Cabs Limited. Reverse the order, it becomes New Territory Taxi Radio Association. And then you have the Fraternity Association of New Territory Taxi Merchants and the Fraternity Taxi Owners Association. Hong Kong and Kowloon Taxi Company Association and Kowloon Taxi Owner Association and Taxi Association Federations. Now, just imagine how many permutations you can come across. And as if this were not enough, let's look at even more closer. Lei Yu Moon Ko Chiu Road Public Light Bus Merchant Association. Why not Kok Fu Lam Bun Ham Road Bus Association? And maybe we can run a KK Leung Zheng Yu Kong Buildings Shuttle Bus Association. And it is not just the people in that profession. It is interesting, and it might provide us with some clue as well. In this subsector, there's a Maritime Affairs Research Association. Apart from the word maritime, which has something to do with transport, is there anything else that has to do with transport? And then there's an organization of Hong Kong drivers. Presumably, most people here with a driving license are eligible to join. It may be more restrictive than that. And there's a Merchant Navy Officer Guild, Hong Kong. I'm absolutely at a loss what this is. And interesting, there's a taxi and public light bus concern group. There's no shortage of concern group in Hong Kong that you can put in. But on the one hand, and one can imagine also, looking behind the corporate veil, how many overlapping members there may be in these associations. But then the problem of these is that the process and the criteria are absolutely unclear. How to get on with this onto this list? The list itself is published in the ordinance, but who decides who should get onto this list? What are the process? What are the criteria? And the selection process is governed by Hong Kong law, by the Hong Kong government, which in a way also provides the room, therefore, to move forward if one wants to make these subsectors more representative. It is a matter of Hong Kong law. The Hong Kong governments could, in a way, expand the list, make it more inclusive, make it more transparent, and expand the representativeness of the nomination committees. And when the Hong Kong governments early on suggest that they are prepared to make maximum effort to expand the representativeness of the nomination committee, would this be one area that at least they can make some concrete improvements on the representation of these elections committees? Back to that then, back to the Article 45. If the nomination committee itself is not broadly representative, then what? And is it an exclusive? And this is the argument that if it is not broadly representative, then at least we can make the procedure more open. And the argument against that is, well, Article 45 refers to nomination committee, and that is exclusive. You can only have nomination by the nomination committee and nothing else. As a matter of literal interpretation, this is a respectable argument. But then if we look at the earlier part as well, this same article also refers to selection by universal franchise. And what does universal franchise means? A very narrow reading could mean that it means the actual casting of vote. So if every voter in Hong Kong can cast a vote, that is election or selection by universal franchise. A more sensible or more liberal reading would refer to the entire process of elections. So from the very nomination up to the casting of vote, that is what is meant by selection by universal franchise. Then we can look at the whole process to consider whether that falls within the meaning of universal franchise. And of course, one can be aided by other articles in the Basic Law, and it is a general principle when you interpret the Basic Law, you look at the Basic Law as a whole. And Article 26 there refers to the right to stand for election. there's an incorporation of Article 25 of the ICCPR. And the Human Rights Committee under the ICCPR make very specific comments on the meaning of the right to stand for election. And paragraph 15 of the general comment say that any restriction on the right to stand for elections must be justifiable on objective and reasonable criteria. And persons who are otherwise eligible to stand for election should not be excluded by unreasonable or discriminatory requirements, such as by reason of political affiliation. And then paragraph 17 said that if a candidate is required to have a minimum number of supporters for nomination, this requirement should be reasonable and not act as a barrier to candidacy, and political opinions may not be used as a ground to deprive anyone of the right to stand for elections. So if one takes all these together, even if the nomination committee is not broadly representative or sufficiently representative, nonetheless the procedure may come in to counterbalance it. And when we look at the procedure, basically the requirement, and it's not something very difficult to understand, the nomination process itself should not be subject to any unreasonable restrictions. But even that, putting that case to the highest, it simply means the nomination process should not be subject to unreasonable restrictions. That there is still a few steps before you can lead to, therefore, there must be civic nomination. And civic nomination, in a way, could be a means rather than an end. It may be one means to ensure that there is no unreasonable restriction, but it is not the only exclusive means, and it is not easy to infer that directly from Article 45. There are quite a number of proposals that have been put forward during the consultation process, which suggest that there may be other models that could achieve the requirement of no unreasonable restrictions, but nonetheless fall short of having civic nomination. It seems that this is necessary, or this may be the time that we revisit those models. And there's also the 50% threshold. We have seen that a high threshold could also amount to unreasonable restrictions. So in a way, it comes back to the basic when we impose, or when we put forward, or the processes put forward the requirement of civic nomination as if it were a principle. It seems to me that from the very beginning it is a means rather than an end, but then somehow in the process it has been elevated into a principle. And at this point of time, could we be more flexible, take a back seat and look at the whole things again? Should we go back to the basic, and the basic is there's no unreasonable restrictions, and be more flexible with civic nomination. And the way forward, when it comes to the end, if there are if a table is to be made up of two planks, and if two planks cannot fit with one another, the artist's job is to cut a bit from each of the planks and try to fit them together. And that seems to be the way forward. And for the protester, if after the analysis we have to go back to the basic about no unreasonable restrictions, could they be more flexible on civic nomination? Not necessarily have to give it up, but at least this is not something that you put at the forefront, and let's go back to the principle and see whether we can explore other alternatives before you come back to this as your last resort. And the Hong Kong government, of course, there are rooms for the Hong Kong governments to put forward more concrete and more specific proposal to expand the representativeness. Even within the current framework of the NPC decision, there are still rooms for the Hong Kong governments to take more initiative and be more specific at this point. As far as the central government is concerned, the threshold 50%, is it unmovable? I think there could still be room to manipulate or change it as a technical amendment. And I think to move forward, the way to do it is we have to have more constructive and creative thinking, and perhaps less finger pointing. And with that, I hope that may pave a way forward. Thank you.
Thank you very much, Johannes. I invite Eric to speak on injunctions.
Thanks. So my talk will focus on the injunction and rule of law. So first I set out certain details, dates, etc. of the injunction, because I've been told by my Lord and Famurius there's no civil disobedience allowed to his order to cut short my talk. So I won't go into the details. So you just read it, and so basically there are three actions, and basically is based on public nuisance, and one action is based on both public and private nuisance. And so, quickly, I just want to highlight some reservation and stretch aspects of the injunction ruling, not injunction. So first of all, I can see that as far as the ex parte order is concerned, I do have great reservation because I can't see any extreme urgency to justify the making of the order on ex parte basis on the 20th of October. I think this point was addressed briefly by Mrs. Out concerning strict injunction, saying that it may involve some danger, so there's some extreme urgency, but rather doubt in the fact. But anyway, he hasn't addressed why in a Mon court there's extreme urgency. You have to grant it on ex parte basis. It's unlike Murphy injunction that there's a need for secrecy, there's no secrecy at all. So the other point is that when I read both Kuhn and Ao's judgment, I find that they adopt a traditional Murphy threshold of serious issue to be tried, which is a very low threshold. But I think this shouldn't be applicable to cases where the context for the grant or refusal of the injunction will effectively dispose of the whole action. Because we all know that if the injunction is granted, if people obey the injunction, that will be the end of the occupied action in far as those sections is concerned. So there are whole sort of authorities to say that that shouldn't be the right threshold to be adopted by the court. Just quickly, you can see the judgment of Deputy Judge Carlson, which highlights that a much higher merit threshold is required. I think the basis is common sense, because effectively there won't be a trial. So the traditional approach of serious issue trial should be adopted, but effectively you are granting a summary judgment against the defendant. So you need to adopt a much higher threshold, but that point apparently has not been considered by both judges. And then the third aspect is that there's a very minor one. I looked at the court order side. It was against all the defendants, but look at the legal aid ordinance, section 16C, and the CFA judgment. There shouldn't be any court order against an aided defendant. And lastly, there's a rather unsatisfactory aspect is that you can't access the actual orders. You can read the judgment, but the judgment does not tell you what exactly is being enjoined or prohibited. This is very, very unsatisfactory. It's nowhere available in public. I understand that there's requirement to advertise, but nowadays, who reads advertisement newspaper? I can't find advertisement myself unless with some diligent research. It is very unsatisfactory because people may pass by Mongkok, may pass by Fifth Tower. They need to know where they stand. So, and then my point is about these rule of law issues. Of course, Mrs. Ao has dealt with it briefly, and I highlight this three paragraph. First, I don't have too much quarrel with what he said. Of course, that is a very partial or incomplete discussion of the rule of law. But that's understandable because his judgment is not intended to explain what the rule of law is. It's just want to focus on one aspect of rule of law, that you have to obey the law, obey court order. Of course, I can't quarrel with it. I can't say that you don't need to obey court order. Okay, and in this, so my quick point is, does this deliberate non-compliance undermine the rule of law? The answer is yes, because it does undermine the dignity and authority of our independent judiciary, and so should be discouraged. That is the stance taken by me from day one when the party order was granted. The next day when I was interviewed by the media, I said the same thing, and a few days later the Bar Council issued a statement. And again, I don't have too much quarrel with all this, because I think in Hong Kong, one important aspect of the rule of law is our independent judiciary. So we have to uphold the dignity and authority of our independent court. That is one important aspect of rule of law. So that, to some extent, changes the focus of this civil disobedience movement. Because originally, it targeted at breaching some written law made years ago by the Legislative Council and government, in particular the Public Order Ordinance and other traffic and other offences. So in that, I think you do have a good discussion on this by any jurist that civil disobedience basically you just deliberately choose to disobey some law in order to expose injustice, and whether you're successful depends on whether the silent majority accept or are sympathetic with what you pursue. Okay, but now if you are disobeying a court order, I think it changes the focus to me. It changes the level because, or put it this way, I think to some extent the original civil disobedience actually you can say that it's successful to some extent. To me, it actually exposes whether our public order ordinance needs to be amended. Because we all know that now no one actually complies with the POO. And we find that there's not much problem. In particular, in the POO, so as you have 30 people marching on the street, you need prior notification, etc. You need, so as you have 50 people meeting together, you need prior notification. But we all know that now, basically, all these provisions are honored in breach rather than in compliance. So that is the time that would expose whether the current legislation is satisfactory, and that is something that government, I think, has to review the POO at the end because of this civil disobedience, but not for the judiciary. But to complete the picture, I want to add the word but. To me, we need to bear in mind that the ability of the powerless citizens to undermine the rule of law is very, very limited, and in this, that can easily be remedied. What can be remedied would be the unrestrained exercise of blatant power by the state and those in power that would cause irreparable damage to rule of law. I think that is something that, to be fair to the protesters, that needs to be emphasized at the same time. We have lots of examples, starting from the first interpretation, government having lost the battle before the CFA, sought to seek interpretation from MPCSC to overturn the CFA decision. I think that would clearly undermine the dignity and authority of our court. Indeed, after that interpretation, every time when the basic law issue was debated before the court, the media would ask government whether you would seek interpretation. Government's standard answer is that we need to wait and see how the court ruled. With the judgment before we decide whether to seek interpretation, then clearly undermine the rule of law. That cannot be remedied. Quickly, some other examples. The MPCSC's interpretation mentioned by Professor Albert Chen. Look at the basic law. Only 3-step procedure for Annex 1 and Annex 2 amendment. Okay, now we added 2 steps. First, the CE need to make a report as to whether there's a need to amend. And secondly, MPCSC need to determine on the need. But then, later on, the free decision, not just determining on the need whether to amend, the MPCSC decision actually set out the exact parameters of the amendments of the CE elections. Okay, it goes further than its own interpretations. And then, look at the most recent decisions. The role of the nominating committee is no longer a nominating role for a genuine choice for the Hong Kong people to elect our CE. Rather, the whole design now are now 601 NC members to determine who can stand as a candidate. So long as you have 601 NC members grouped together, back together, they can determine candidate A should be the genuine CE, and then we can get 2 others who will stand no chance to win. That is the design. So long as you allow that to happen, I don't think there's any genuine universal suffrage. And then the MPCSC interpretation 205, basic law 46, clearly said that the term of office of CE shall be 5 years. Years before, Hong Kong government also made that clear that even if a current CE sort of vacated his office sooner, the term should still be 5 years. That was a step taken by Hong Kong government. But we all know the history. After Tong resigned, and then the central government intended to have Zhang to stand as the new CE, but only on probation for 2 years. They make an interpretation to say that notwithstanding a clear wording of Article 46, now the term of office should only be remainder. So, and of course we have lots of other examples. it shows that those in power are allowed exercising an unrestrained naked power that would undermine our rule of law more. Because for citizens to disobey the law, even the court order, well, basically, the state can do is to punish them, to enforce the law. Indeed, all civilized society with rule of law need to deal with people who deliberately flout the law. That will undermine the rule of law so that they can effectively help the law. But now, why Hong Kong government so far has not taken any action so far? This exposes the problem of governance. Because normally you expect that people take civil disobedience, government then enforce the law, and then clear them away. So there won't be any undermining of rule of law. But now we are in this abnormal situation that we cannot hear. So I will just end here. There's no more civil disobedience to ignore shift order.
Eric. I'll invite Ronnie to say a few words on civil disobedience.
Thank you, Simon. I have no slideshow to show, but it is my professional sickness to want to speak when I'm standing up. Needless to say, I'm very honored to be given the opportunity here to be the odd man out, because I'm the only one who is not from the academia. But let me start by giving a general observation which struck me when I was invited to come here. Ask any lawyer to give his view on any topic, and he will give you 10. Ask a good lawyer, he will give you 20. So imagine my horror when I was invited to come here, and I count on the fingers of my hand, there are 1, 2, 3, 4, 5 lawyers to talk about something as nebulous as civil disobedience. Unfortunately, up to now, only one speaker has touched on this topic. Now note, I said nebulous, because if you care to look it up on the internet, you will be surprised to hear or to find that there are as many views on civil disobedience as there are aspects. There are views ranging from, say, passive protest to active resistance, from pleading guilty to contesting guilt in the court of law, from protesting a law, a government policy, to government administration, and most fundamental of all, even from the use of violence to non-use of violence. But there is a general consensus to be found that there is a common factor, and that is a willingness to respect and accept a legal system. Now that is the only marked difference between civil disobedience and open revolt or armed revolution. Note, I said legal system, not a law. Now, although we all know civil disobedience started out as a form of protest against a particular law, its proponents never sought to argue that participants should escape legal punishment. That, in fact, is a willingness to accept legal punishment under a lawful legal mechanism or system. Now this itself, in fact, is important because it represents a respect for the rule of law. Respect for the legal system is not so much as part of the content of the rule of law, but the very foundation of it. For without respect, the entire philosophy of the rule of law cannot flourish. But this is quite different from respect for a particular law. Breaching a law is not necessarily an affront of the rule of law, because of course, but of course, persistent and widespread disregard of the law can amount to an affront to the rule of law. That is in fact what Judge Au said in his judgment, and the Bar Association said in their statement. Why I say that? This is because that there are no society in this world who can claim that he has a crime-free environment. Every day, everywhere, at some point of time, people are breaking the law. Does it mean, therefore, that there is no rule of law anywhere else on this planet? Of course not. On the other hand, if you start disobeying a court order, it is something slightly different. You can disagree with the court decision. You can even openly criticize it, as Eric does. But not complying with the court of law is equivalent to negating the very system of the law, because by complying with the court decision, you're not complying with the wishes of the judge. You are paying respect to the office being held by the judge, which is an integral part of our legal system. That legal machinery, that legal system, is the very essence on which the rule of law is built. Now, some prominent public figures themselves, well-known lawyers and advocates of civil disobedience, argue that as long as participants were to turn themselves in and accept legal punishment, that is enough, and the rule of law will not be harmed. Well, I venture to think that such rhetoric suggests the speaker has confused or misunderstood the important difference between breaching a law and disobeying a court order. Now, before I leave this topic, I must also say a few words about persistent disobedience of the law and the court order. There is no doubt that widespread and persistent disobedience of the law is an affront to the rule of law, more so as regards a court decision. Someone said to me just the other day, he said, Ronnie, you should be happy to hear that the recent poll shows 75% of the people in Hong Kong thought that a court order should be complied with. I cringed with fear and sadness. 75%? What about 25%? How many people does that percentage translate into? 2 million. 2 million. I'll be very unhappy if there are 200 people out there who openly define a court order, not to mention 2 million. Recent events show not only, I'm sorry to say, we're not familiar with the very essence of democracy, something which we never had. But sadly, we are also not at all familiar with the rule of law, which we all boast to be our core value, the very fabric of a society which we all call home. Democracy and the rule of law has got to walk hand in hand. You cannot and must not forsake the rule of law because of democracy. Because democracy without the rule of law is but a political tyrant with a better name. Thank you very much.
Thank you very much, Ronnie. I'll ask Simon Young to say a few words on prosecution policy.
Chairman, I will be obedient because my presentation is actually on this blog. And what I plan to do is just summarize the main points in my presentation. First thing I say in this article is that there needs to be an appropriate prosecution response to Occupy Central in order to reaffirm the rule of law and also to restore people's confidence in the legal system. And so I do believe there has been damage done to the rule of law. Not so much because of civil disobedience in and of itself, mostly for the reasons that Ronnie Tong has just given. Because with civil disobedience, the individuals tend to accept that they breach the law, and that they accept the punishment. And we hear that theme with many of the protesters. So in a way, if you accept that you're going to accept the punishment, that in a way reaffirms the rule of law. But what I see with Occupy Central and what's happened over the past few weeks, where the damage has been done, is that it has caused many others to breach the law. We've seen the violence on the TV screen. And that, I think, is damaging. And I think more so is the response of public officials. And this is the same point that Eric has made, the non-enforcement of the law. That, in many ways, has been damaging. And that's why I think, going forwards, the prosecution response has to be appropriate. And that doesn't necessarily mean that everyone who's committed a crime or may have committed a crime needs to be punished, because that could be hundreds, thousands. And so what I want to talk about is what is that appropriate prosecution response. The first thing, of course, is that it has to be an apolitical response, that it has to be completely divorced from politics, and that's exactly what Article 63 of the Basic Law says, free from any pressure. And in fact, if you take that seriously, one may even go as far as saying that perhaps the Secretary for Justice should withdraw himself from any prosecution decision that arises in relation to Occupy Central. Simply because many of the protests are directed at the task force and the decisions that, and the work of the task force, of which he was a member. So that would be my first sort of proposal. The second is that, of course, the Department of Justice should follow their existing practices and policies. And it turns out that there have been quite a few policies in this area, given events in the past few years. And in this article, I trace some of the statements that have been made by the Director of Public Prosecutions in regards to public order matters. And I describe this practice and policy as one that highly emphasizes diversion, that is, diversion out of the traditional system, recognizing that this is conduct that's done in pursuance to the exercise of fundamental freedoms. And it's stated very much in their policy report guidelines, the Prosecution Code 2013, Section 19. There's a section on public order events, which first acknowledges the importance of the fundamental freedoms, and then it goes on and says, criminal prosecution should only be pursued when the relevant conduct exceeds sensible proportions or the bounds of reasonableness. And I submit that that also should apply in this context where there has been civil disobedience. And so this approach of restraint and diversion, when applied here, would mean that if it's conduct, although it may have breached the law, technically may have been a minor offense of unauthorized assembly, unlawful assembly, maybe assault, or maybe even criminal damage to property, if it was done pursuant to nonviolent protest, and civil disobedience, then some diversion out of the system should be considered. This is consistent with existing practice, where many, many cases have been resolved by reference to a bind-over, right, where although a charge is laid but withdrawn, and the judge binds over the individual for a period of time, or by reference to a warning letter, or other alternative measures. And I think only when you cross a certain line, for example, where you cause injury to a person, serious damage to property, or more recently now the criminal contempts, do we apply the usual two-part test to determine whether there should be a prosecution. Again, this is the prosecution's practice. First, that there has to be sufficient evidence, reasonable prospect of conviction. And secondly, it has to be in the public interest. And in this area, there has to be, there can be a number of different considerations that are relevant, and I highlight three of them here. Firstly, it's well recognized in case law in different jurisdictions, particularly Canada and the UK, that when the individual is breaking the law pursuant to civil disobedience, that is seen as a mitigating factor, and that it reflects one's motive and reflects a lesser degree of moral culpability. So that needs to be taken into account. Secondly, the cooperation, remorse, and compensation to the victim. Again, if you have those things, the public interest tends not to be in favor of prosecution. And so therefore, we've heard many of the protesters say that they're prepared to cooperate and admit responsibility, so that's in their favor. But what about compensation to the victim? This is really quite interesting. Who's the victim here? Well, we could say all of us are victims. And so I suggest that perhaps there could be more creative measures where individuals agree to do voluntary community service as recognition of their compensation to the community. And that would weigh strongly in their favor to have their case diverted out of the system. So there are these ideas that can be applied here. There doesn't have to be a prosecution that takes someone to court and then possibly to jail. And then lastly, of course, the most important thing, given that there are a lot of young people involved here, is age. And we have to be conscious of our treaty obligations. The UN Convention on the Rights of the Child. Child is defined as someone who's under 18, right? Many under 18s may have been involved here. And the treaty obligations say very clearly that these individuals should be diverted out of the system. There's a strong principle not to involve these people through the traditional criminal justice system. Right? Thank you very much.
Thank you very much, Simon. That concludes the first part of this forum. We've heard a range of views on a variety of matters. I should stress that the views expressed are those of the speakers involved and do not reflect the views of the Faculty of Law or the University of Hong Kong. In the second part, I propose to open the forum to questions, comments, observations from the floor, from the audience. But as I mentioned before, whatever you say, you must keep it short, succinct, to the point. You may ask your question in English, Cantonese, or Putonghua. I would ask that when you make a comment, question, or observation, you first identify yourself and that you address whatever you're going to say to me, and then I will direct the question to a member of the panel. We have about 55 minutes for this. We will conclude this round of questioning promptly at 4:20, and then there will be some concluding remarks. I should also point out that Professor Albert Chen, has a teaching engagement at 4:30, so he apologizes if he has to be excused at 4:15. It doesn't mean that he's walking out in a huff. He's simply going to meet his teaching commitments. So I would like to invite questions, observations, comments from the audience. Margaret Ng.
Thank you, Mr. Chairman. A lot of emphasis has been placed on obeying, respecting the court order. And I think that there is another part to it. As lawyers, our job is not only to urge people to respect an order of the court, but also to make that order of the court worthy of respect. Of course, disobeying a law is a more local thing than disobeying a court order, because when you have a court order, disobeying a court order is to challenge the process of adjudication, and that of course is a deeper level. But if that cause of resolution is itself powerful, but at the same time not fair, then you have a more serious problem of the rule of law. So I think that this is the aspect of the question at the moment which has not yet received sufficient discussion. Eric has just talked about the injunctions. And we have to look at, if an injunction is hastily given and is on totally wrong basis, and we are here to urge everybody to obey it at once, and if subsequently we find that there is no basis for such an injunction, then that must mean that the rule of law will somehow be tarnished. So I think at this point it is very important that the community also learns about the process of going to court, of putting reasons for and against, and of a court which is capable of looking at these reasons and the process fairly and in a manner which is worthy of the administration of justice. That has not been discussed.
Thank you very much. But I remind you of the protocol. First, introduce yourself. Could I perhaps invite, I think everyone knows who you are.
Because, Mr. Chairman, you've mentioned my name, I didn't want to. You have already mentioned my name, so I didn't think that I ought to challenge you.
I invite Johannes to respond to that.
I'll defer, nothing to say at this point.
Eric, would you like to respond? And then I'll come to Ronnie.
Well, just a quick response. I think Margaret has raised a point here. But of course, the other point is that because under our court system, we do allow a fair and impartial hearing. So if people think that they have good arguments to criticize the court's judgment or persuade the court, I think the whole point is that they should follow the court process. On the other hand, not to make a good point, a quick point in the sense that if, notwithstanding what we have urged, etc., for people to obey the court order, if at the end there are still people who choose not to obey the court order, the point that I made is that at the end, to me, their ability to undermine the rule of law in that aspect is rather limited, because in the normal situation, we expect that government can then take action, or the court can, in its judgment, in dealing with the contempt proceeding, explain what the court order is, and try to explain it in a way that can earn the respect of the people. Of course, if the court cannot do this, then that's something that may, I agree with Margaret, that may at the end undermine the people's respect for the court decision. So that provides kind of check and balance, because the court is also open to being monitored by the Hong Kong people. So they have a duty to explain their decision in such a way that can earn the respect of the people.
Ronnie.
I'm Ronnie Thompson. I disagree with Margaret. There are, of course, legal systems in the world which does not qualify to uphold the rule of law, where the court system is not independent, the law is not being applied equally to everyone, including the government and the individual. It is not accessible to everyone. So, of course, there are such systems. But where there is an independent judiciary, as we think we have here, any workings which needed to be done, in the words of Margaret, to make a court order worthy of respect, ought to be done within the system. Just imagine what Hong Kong would be like if everybody, every one of you, would impose your own personal sense of fairness and justice over the validity or effect of the court order. What would happen? So I think it is wrong to say that asking people to comply with the court order is wrong itself. Any such notion is extremely dangerous, particularly in the present atmosphere.
Thank you very much. Other questions, observations? At the back of the room.
Thank you. My name is Dan Garrett. I'm a PhD student at City University of Hong Kong. Based on some of the MPC Standing Committee's decisions and some of the statements that have been made, it seems that the requirements of patriotism are incompatible with the basic law, how it stands. Article 25 and Article 26, that were raised earlier, mentions that all Hong Kongers are created equal. They have equal political rights, and that all Hong Kongers can stand for election within certain demographic restrictions. So it doesn't address the issue of patriotic or unpatriotic Hong Kongers. Also, the nomination committee, which seems to be intended to screen out anti-China or anti-communist candidates. Patriotism has not been defined, has not been codified. Neither has the requirement of not confronting the central government. Who decides that? What constitutes confrontation? Is criticism confrontation, or is it some other action? Those would be my questions. Thank you.
Thank you very much. I invite Professor Albert Chen to respond.
It is true that the Basic Law itself does not contain any provisions on this question of patriotism. There are quite a lot of writings on the part of mainland Chinese scholars who try to derive this requirement of patriotism from the text of the Basic Law. And the NPCSC decision itself also tries to explain why this patriotism requirement can be based on the Basic Law. I think I in my presentation I already referred to that provision in the Basic Law, which requires the chief executive to be accountable to the central people's government, in addition to being accountable to the people of Hong Kong. I think the central government's view is that the power to appoint the chief executive under the Basic Law is a substantive power and not just a ceremonial or symbolic exercise. And the Basic Law does provide that any person who is elected in Hong Kong, whether by the election committee at the moment or by universal suffrage in the future, will only become chief executive if and when appointed by the chief executive, if and when appointed by the central people's government to be the chief executive. So what we have under the Basic Law is a mixed system of election and appointment. It's not like, say, in some federal systems like USA or Canada or Australia, in which the leader of the executive branch of government in a province or a state, like the governor of a state in the US, or the chief minister of the government of a province in Canada or Australia, they are directly elected by the people, and the federal or central government has no say as to who they will be, because there is no procedure of appointment. So I think the central government's position is that there's nothing which requires the central government to appoint somebody as the chief executive of Hong Kong if that person is considered by the central government to be not appointable, in the sense that maybe the central government does not trust this person and believe that the appointment of this person will prejudice what is called the sovereignty, the security and developmental interests of the People's Republic of China. So I think the decision of the NPC Standing Committee is based on the concern that if there are no controls or what we call screening by the nomination committee, it is possible that somebody will be elected by the universal suffrage in Hong Kong whom the central government considers to be not appointable. It is noteworthy that Mr. Li Fei said more than once that one of the purposes of this system of nomination is to minimize the risk of what he calls a constitutional crisis. And he describes constitutional crisis as a situation when a candidate is elected by universal suffrage in Hong Kong but is not considered appointable by Beijing. And if Beijing refuses to appoint him or her as chief executive, there will be a constitutional crisis. I suppose what he refers to as constitutional crisis is maybe some kind of turmoil or instability in Hong Kong, when people in Hong Kong engage in large-scale protests, similar to or more serious than what we have seen in the occupied region. So that is what I believe what the central government has in mind. But this is only based on the study of the relevant texts and speeches and the study of the central government's policy towards Hong Kong.
Thank you very much. Other observations, questions? The person with the yellow sweater. The yellow sweater right there. First, you introduce yourself, please.
姓李嘅退休人士，足夠。想請教關乎2004、07啦，同埋而家呢個人大常委嘅決定係咪合憲法咧咁樣？咁我首先提出咗我一啲睇法先啦。咁04年嘅睇法咧，提出咗有個政改嘅5部曲啦。咁基本法要運咗到釋法自然嘅基本法要持續啦，人大常委嘅釋法要令到香港運作要持續。咁如果佢將呢一個第一點就特首提個報告嗰啲上去經俾人大常委考慮，需唔需要政改？咁嘅時間係咪已經將呢一個政改嘅立法權可行性交翻俾人大，而基本法運作喺香港嚟講唔係持續咧？第一點，呢個我覺得想請教下，呢個叫做釋法嘅合憲性。咁就算呢個合憲性合憲嘅話咧，07年咧佢就特首交咗報告咧，人大作出嘅決定似乎唔係一個釋法，係一個行政決定嚟嘅，因為佢提出咗嗰啲組成部分等啦，然後呢個決定佢認為有憲法嘅出入，即係香港。喺咁嘅情況之下咧，交埋香港立法會係冇可能提出憲法即係立法呢個選舉法修訂咁會變咗出現咗一個香港立法嘅危機，就係話本身你香港冇可能提出選舉法修訂而人大嘅決定已經適用或者係香港實施咗咁樣，咁呢個係咪符合憲法合法性咧？如果有人大嘅決定，我覺得人大嘅決定唔係一個立法嘅釋法。如果你決定係正確成立嘅話咧，香港永遠唔可能提出選舉法修訂嘅。咁從2007年呢個咁嘅決定咧，又引申咗今次決定啦。咁上次咧冇人反對嘅話咧，今次決定就係話我呢個決定咧又係適合於香港。咁嘅情況又出現咗問題，就係話香港永遠只可以接受嘅決定，呢個行政嘅決定咧已經變成香港法律嘅一部分，就係選舉法本身，你係唔可以超越個選舉法，因為法律決定已經定咗落嚟啊嘛。咁所以從嗰3點我就係話，究竟2004年嗰個所謂釋法 雖然人大常委係有釋法，但係佢釋法應該有原則，就係釋咗法之後，呢個釋法本身要香港法律系統有自足性去理解同執行，先係合理。咁佢似乎係做唔到呢條，導致到今次嘅矛盾啦。亦因為咁咧，上咗經之後，今次咧交咗份嘢上去，係咪想？
I think we need to get to the point.
我就想問人大常委04年、07年、12年，即係今年呢個所謂決定係咪合乎基本法同埋中國憲法咧？
Thank you. I'll invite Johannes and Eric to respond.
The question I think raised an interesting issue which have not been fully addressed in Hong Kong so far is what is the status of a decision of the Standing Committee of the National People's Congress and a decision as opposed to an interpretation. Under the Basic Law, Article 158, the NPC Standing Committee has the power to interpret the Basic Law, and that is accepted by the Hong Kong court. But that pursuant to that interpretation, the NPC make further decisions under that. Now, what exactly is the status of those decisions, and how far those decisions could go? That is still an unresolved issue. As far as 2004 is concerned, I think it falls within the parameter of 158, because the issue at that time is that if there is a need, then the compositions and the formation of the legislature and chief executive can be changed. And the question is, who decide whether there is a need and what is the procedure? So technically that is still within the framework or the scope of interpretation. And then the NPC decided, or the Standing Committee decided, yes, it is the NPCSC which decide whether there is a need, and in so doing they lay down the 5-step procedure. I think as far as that part is concerned, I think it comes within Article 158 and within the power, and we have to accept it. But then we have a number of decisions which then further expand on this power, apart from whether there is a need. Now it is a decisions which set out all the parameters for Hong Kong. These, strictly speaking, are not the interpretation. These are filling in the gaps and filling the gaps through an administrative procedure which allegedly have binding power on Hong Kong. Now that would be the difficulty. Where does that binding power comes from? Would that gives the NPC Standing Committee a decision through administrative decisions, make laws for Hong Kong, which under the Basic Law, these decisions are not the sources of law or does not have any legal status within Hong Kong as such. I think the legal argument one can make, the political reality is, of course, if technically we can ignore the NPC decision as far as the parameter, taking my argument logically, all they need to say is whether there is a need, and going further, these parameters are probably outside the scope of power. They can make that suggestions, but those suggestions are not binding on Hong Kong. But then when Hong Kong passed the law by the legislature, and assuming we can get 2/3 majority, there is a further power that they can veto the law if this is not in compliance with the Basic Law. So in that sense, although the restrictions now, even if we can argue that it's not binding, it would come back at the end of the process that they could veto the legislation passed by the legislature on the basis that it is not in compliance of the Basic Law. But in that case, there will have to be another interpretation of why it is not. And even so, the Basic Law provides that if they think it is not compliant with the Basic Law, they cannot change the law. They can only send it back to Hong Kong. But I think that the technical legal issues as to the status, and particularly not only the status, but the scope of how far these decisions could make, that has not been fully considered and tested.
Eric, would you like to add anything?
Yes.
And I'll give the final word to Albert.
Yeah, very quick. I think this exposes the tension of one country and two systems, which is unprecedented. Because the concept of rule of law in China is very, very different from the concept of rule of law in Hong Kong. And that applies to the concept of what is constitutional or what is not constitutional. So the simple answer is that according to the Chinese system, what is constitutional, this is according to the rule of law, all these decisions. So of course, whether that of course with the Hong Kong concept is another matter. And quickly, the earlier questions about the need for being patriotic and the NPC decision, I think we fall into trap latest NPC decision and the need to ensure that CE is patriotic. What the decision now does is to confer upon 601 NC members making power to determine who can be the CE. They are not in a better position to determine who is patriotic or not patriotic than Hong Kong people. Okay, but this gives the power to this 601 NC member to determine who can be a CE, who can be the candidate, but they won't be a CE because they won't stand a chance. That is not a genuine election. That doesn't achieve the professed purpose of ensuring that someone is patriotic. Indeed, the central government can always not make the appointment if Hong Kong people choose someone whom they don't accept, but they don't want to exercise their power, but they want to leave the power. These 601 NC members.
Thank you. Albert, would you like to say anything?
I agree with what Johannes has just said concerning the political reality, and also I agree with his legal analysis. So I think Mr. Li Fei has made a point similar to what Johannes just said. I think when he came to Hong Kong to explain the NPC Standing Committee's decision, he did address the question of whether the Standing Committee decision can only deal with the question of need, i.e. the need to reform the electoral system, and whether the Standing Committee can go on to say something more about how the system should be reformed. And he said that, well, this step two of the 5-step procedure is the only occasion, apart from step 5, on which the Standing Committee can express its views about what kind of political reform is permissible or is consistent with what the basic law calls the actual circumstances of Hong Kong. So he said that, well, if we don't give you the indications as to what we think are the parameters for the reform, and you go about it in the wrong way, at the end, when you come to step 5, we will have to veto the package. So the whole exercise will become fruitless. So I think that is how he justifies the setting of parameters or conditions in step 2 by the Standing Committee. As regards the point which Eric has just raised about the patriotic requirement and the model of nomination, I believe that there is indeed some connection, but I think it's, maybe this is not raised in the original question, so maybe we will not deal with it at this stage.
Thank you very much. Other questions? Here in front.
I'm Peter Cheung. I'm a faculty member in politics and public administration at this university. I think the government has publicly said that the protest movement has caused a lot of problems to Hong Kong's public order and stability, have great consequences. But at the same time, the government has not enforced the law. So, as an ordinary citizen, I'm very curious as to how we should interpret the government's inaction. So is the government's inaction also undermining the rule of law? We are witnessing not a lot of angry protesters or heavily armed protesters, a lot of people camping out. Why hasn't the government enforced the law? When you see it as a great threat to public order. So can this inaction be used as a mitigating factor if indeed the protester later were prosecuted by the government? Thank you.
I'll ask Simon to respond.
Thank you. I think that's an important consideration, and I agree with your sentiment that the lack of enforcement has damaged people's perception of the law and confidence in law enforcement. And hence, I think that has to be taken into account in prosecutorial decisions. We know that more than 320 people have been arrested, and if you haven't been arrested yet, and you're to be suddenly arrested later on, I think government and police would have to really have good reasons for that, to justify that. Otherwise, I think it should be a safe assumption that nothing will be done, or at least there should be a clear announcement to that effect, so that people have some certainty in their daily lives.
I think Eric has already said something about this in his talk. I'm going to ask Ronnie to add a few words.
Just to add a few words, I totally agree that failure to apply the law timelessly is itself an affront to the rule of law. That offends the rule against applying laws fairly and equally within the jurisdiction. However, having said that, I don't necessarily agree that it will be a litigating factor, because two wrongs don't make one right.
Thank you. Other questions? Right at the very back. The one in the red shirt, I believe.
Thank you. I'm Timothy, HKU law student. My question is, my starting point is Beijing's requirement on Hong Kong CE that Hong Kong CE must be patriotic, must love Hong Kong and love China. So my question is, assuming the CE elected by genuine universal suffrage to reflect the majority view of Hong Kong people, then Beijing's fear of the unpredictability of the CE candidate reflects fear that Hong Kong people are not generally love Hong Kong and love China. So the thing is that a condition that Beijing may impose on Hong Kong as to the genuine universal suffrage, that Hong Kong people must impress Beijing, that the majority of Hong Kong people love Hong Kong and love China. And so my first question, is that the condition? And the second question, is that condition an exercise of the rule of law? Thank you.
I'll first invite Eric to respond, and then I'll ask Johannes, and then finally I'll ask Albert if he has any words to add. Eric.
Well, I think the question actually raises the irony, because as far as we can see, the Chinese officials have kept on saying that the majority of Hong Kong people are patriotic. So there shouldn't be any worry that giving us a genuine choice, we will elect someone who is not patriotic. So it's difficult to answer you, because to me, I think the main problem now with the current design under the latest MBCSC decision, as I mentioned, I can't see any rational connection between the two. Indeed, what I fear is that ultimately the NC will not screen out any pan-democratic candidate, because he stands no chance to be a CE. But what we screen out will be some other pro-establishment figures which cannot earn the favor of the Chinese official, like James Tin or any other who may seek to criticize the power. I think that is the worry about the current design, because I see no worry that they allow Everett Ho or others to stand as the candidates. They won't be elected by all people.
Johannes.
When the white paper was published, there was a serious concern that it required judges to be patriotic. And that was probably not the original intention in writing that statement. And when they discovered that they made that mistake, requiring judges to be patriotic, everyone tried to help by saying that, well, this is not a very difficult requirement. By swearing the judicial oath, they have all been patriotic. If judges swearing judicial oath can be patriotic, why can't the CE swearing an oath and become patriotic as well? I can't see the distinctions. And for lawyers, if you want to impose a condition, it has to be something which is identifiable and which can be enforced. And I don't know how to enforce patriotism. You can define what acts are unpatriotic. And treason, or you define the activities you can, then until they have breached those or violate those requirements, then you can say someone is unpatriotic. But short of that, it seems a declaration or an affirmation under the old ordinance all you can impose. Otherwise, if you becomes a sort of censorship. And it is also a futile exercise. I suppose all the Communist Party's members are patriotic, and all the senior leaders in the Chinese governments must by definition be patriotic. And how many scandals we have seen, and corruption and other things, unless these fall within patriotic act. Otherwise, this is simply a futile conditions to apply.
Thank you. Albert, would you like to add anything?
It is a difficult question because there's never been any clear definition of this patriotism requirement. But I think there's student Timothy who said that there is this fear on the part of Beijing that the election result is unpredictable and Hong Kong people might elect somebody whom the central government considers to be unpatriotic. I think that is precisely the concern of the central government. And I think we all know who are regarded by the central government as patriotic, because in Hong Kong, politicians have basically divided into two camps: the Ginzai Pai pro-establishment camp, also known as the patriotic camp, and then we have the pan-democrats. So there's no doubt that those who are regarded as pro-establishment are patriotic. I think he is, no, it has been said that he is still regarded as patriotic. According to some newspaper statements published subsequently. So we have no doubt who are patriotic among those in that camp. As among the pan-democrats, the very central government officials and liaison office officials said that not all the pan-democrats are unpatriotic, or they said that there are some pan-democrats who are patriotic. So that implies very clearly that some of pan-democrats are not patriotic. So that is the concern, because as you all know, if you look at the statistics, since 1991, all the way up to the present, whenever we have universal suffrage for elections of electoral members, and you know that since 1991 we started to have universal suffrage for election of some electoral seats. So from 1991 until 2012, the so-called pan-democrat camp has always won between 55% to 60% of the popular votes, and the patriotic camp has only won about 40 to 45% of the popular votes. So that is why I think the Beijing government is concerned that if somebody who is a non-patriotic pan-democrat becomes a candidate, he or she might win the election, so I think it's a basic tension in one country, two systems. But you were talking about the mainland conception of the rule of law. But there's also another tension. It's about Beijing's idea of one country, two systems being very different from the pan-democrats or Mr. Ronnie Tong's idea of one country, two systems. Because your idea of one country, two systems is similar to that, say, in US or Canada or Australia. So long as the US state, like California or Texas or the Canadian province, stays within the boundary of its constitutional powers, their governor can be directly elected by the people of the state, and the federal or central government has no right whatsoever to have any say about who will be the identity of this governor. But that is not Beijing's understanding of one country, two systems. I quoted the passage by Mr. Li Fei when he came to Hong Kong to speak, and I quoted that he said that this question of universal suffrage involves a struggle for the power to govern the HKSAR. So why is it called a struggle for the power to govern the SHCAR. If you look at the speech in great detail, he is saying that there are some people who make use of foreign forces, continuously stir up political disputes, pointing the fingers at the central government and attempt to turn Hong Kong into an independent political entity. That's my translation from his speech. So he says that we won't allow these people to become the chief executive. And he said, on the issue of universal suffrage, their views and demands may be summarized in one sentence. Let their representative become the chief executive. This, of course, cannot be permitted. If they are allowed to become the chief executive, this would necessarily prejudice the central government's governing power over the HKSAR, prejudice of country's sovereignty, security, and developmental interests, and damage the stability and prosperity of Hong Kong. So that is the view of the central government. It's not a secret view, it's published. It's in Mr. Lee Fei's speech.
Thank you very much, Albert. Ronnie, would you like to say anything since your choir is mentioned?
Well, I know what I think one country, two systems should be, but that is not the point. I think the point is how the one country, two systems is being defined under the basic law. I think we just have to because I think the one country, two systems itself is a compromise. And it's important to remember that.
Thank you very much. So far I've taken a question from here, 3 questions in front, 1 question in the back. I think I should give this side equal time.
Hi, I'm Cliff Chow, I'm your alum. I think this question is maybe more appropriate for Professor Wilkinson, but and my question is this. Say if a law student or a practicing solicitor or barrister is involved in a movement and is arrested or he's turned himself in, how might this affect his or her professional qualification and how to think about society or the bar association?
Are you asking for legal advice? I'm not sure any one of the panelists is able in a position to give free legal advice on this matter without the intervention of a solicitor. However, Professor Wilkinson may share the benefit of the As I understand it, the question is this, Professor. If a barrister or a solicitor participates in the Occupy Central or Umbrella movement, what are the ramifications or possible ramifications to the person's professional career?
Thank you. I apologize, I'm not dressed. I did not ask a question on this one. I think the answer, unless the participating lawyer does something outrageous, then there will be no negative implication at all. There is an obligation to report any act which involves dishonesty. And I assume there's no dishonesty involved, gentlemen, in what's happening? I'm not aware of any yet, anyway. Otherwise, it has to be a very serious breach of the law. And at least in my subjective opinion, I wouldn't have thought what was going on was a serious breach of the law unless something dreadful happens, like a policeman being seriously injured in the obstruction. I would think lawyers can participate without great fear, just as law professors can participate. So that would be my comment.
Thank you very much, Professor Wilkinson. I'd like to stress that those are Professor Wilkinson's personal views. They should not be attributed in any way to the law faculty of the University of Hong Kong. A number of panelists would also like to give their personal views. Ronnie Kong.
Well, I'm not unused to giving out free legal advice. The answer to that is that the only offense under which he or she can be prosecuted under the professional discipline code is to bring in his act brings his repute to the profession. I don't think that if you were to participate in any form of protest, would bring the profession into disrepute, unless you've done something, as Professor Wilderson has said, drastically dishonorable, dishonest, or whatever. So the answer is no.
I believe there was someone else on the panel who wanted to comment.
Just add, as far as a law student is concerned, if you just fresh graduate, you apply to join the legal profession. In general, you have a duty to disclose any criminal convictions. But then the Law Society and the Bar has in the past consistently applied the principle that not every single criminal convictions will affect your admissions. It has, as Ronnie said, it has to be something serious enough to bring the professional into disrepute. And usually, when it involves dishonesty or integrity matter, that would be more serious.
Albert wants to say something, and then Eric.
Just want to say that Professor Wilkinson's answer and also Ronnie Tong's answer presuppose that no criminal prosecution has been brought against him.
No.
Do you assume that there has already been
Even if there is criminal prosecution, if it doesn't bring the profession into disrepute, I don't think the Bar or Law Society would act.
Eric?
But I also need to point out another reality is that I fear that that may limit your choice of employment. Because many companies may not dare to employ you. I think that is a reality that you need to think about. But that's a sad thing. I don't think Hong Kong should go this way. But that, I'm afraid, that will happen.
Now, I've done one from the front here. Is there any question from the back of this side? I know there are lots of questions on this sector, but are there any questions on this side while you have my attention? All right, now, the person with the bald head has
My name is Malcolm Lyons, and I'm just a businessman with an interest in what's going on in Hong Kong. I've been here for 35 years. We're faced today with the delightful sight of, we can almost see glowing through your skulls, the brilliance of the legal minds. And there are 5 other brilliant legal minds who sit regularly not so far from here down in Central. The way I see it, we're faced with a subject today, the unfolding of the rule of law. Would it not be true to say that what we are bound to see is 5 legal minds faced with constitutional question of great moment in a few years hence on a challenge to the electoral system that we are left with, let's say, by the NPCSC, and that addressing their brilliant legal minds to that question, i.e., does it comply with the requirement for universal suffrage? We're bound to find that it doesn't, because I think we're bound to face the reality that we won't have universal suffrage. And having made that decision, the matter will go on a request from the DOJ up to the NPCSC. And what we will then have is not just an unfolding of the rule of law, we will have it dumped through the Communist Party shredder. And we will have seen, far from what we see now, these trivial acts of public disobedience, trivial affronts, as we've been told by 1 or 2 of the speakers, to the rule of law in Hong Kong. We're going to see the ultimate insult. Are there any comments?
Apocalyptic vision from the questioner. I will ask Eric to respond first. Eric shakes his head. Johannes, and then Ronnie.
I think, right.
Sorry, go ahead.
Yes, I think the underlying tone is if we are going to measure the NPC Standing Committee decisions with the basic law, at least I think within our learning or our system, there is a strong case to suggest that the current system or the current decisions may not comply with the basic law. The difficulty, of course, is we don't have final say on the basic law. On the other hand, is my what I tried to do in my presentation is this is not entirely beyond salvage. There is still areas that you can try at least to minimize the harm. For example, there's nothing said at the decisions about the range or how to make the election committee more representative, and it is still within the hands of Hong Kong government to make it more representative than it appears in the election committee. So this is not impossible. As to whether the future is a doomed future, and my belief in politics is never say never. And if one had not had the persistent demands of the so-called Democrats in the last 30 years, we may not reach the stage that we are, and any attempts to set a doomed future and not doing anything could only result in self-fulfilling prophecy. So I think the approach, never say never, that's the only way to go ahead.
Ronnie Tom.
I'd like to think that the doomed future scenario will never happen for two reasons. If the political package is to be vetoed in national, and I'm sure that it will be vetoed, there is nothing to review. If the resolution is passed, for some reason, nobody in the right mind in Hong Kong will think that is the ultimate universal suffrage package. So that there will continue to be gradual improvements over the years, hopefully not until 2047. So it is unlikely that that resolution itself can be reviewed. Let's not forget the CMA, and we have a CMA judge here, and he can tell you more about it later. The CMA, in fact, did try to say in the early reinterpretation cases that it has the power to review the NPCSC decision. That brought on an intense political storm, which I'm sure nobody in Hong Kong would like to see it happen again. So I think the CMA is very wise to stay away from the issue for the time being. But of course, there may be situations in the future where they will be forced to deal with it head on. But at the moment, I think I'm still hoping against hope that it won't happen.
I believe that Simon has a few remarks to make.
I don't share the questioner's visions simply because when you look at the practice and the experience of our courts in electoral matters, they haven't been extremely robust or very critical, very deferential. I mean, if we had very strong review, one would have thought that the functional constituencies would have been struck down already. Gladys Lee here has been fighting them for many, many years, and they're still intact. So I don't think it's the kind of issue that will attract a lot of attention, of course.
Thank you. We've asked some questions, a lot of questions from this section. Now focus on the front section of my right-hand side. Are there any questions from that section? Yes.
Thank you. My name is Phoebe Smith. I'm from the Australian Consulate General. Johannes mentioned just then and before in his speech about what he saw as the limitations of the current nomination committee, and yet how it could provide an area for constructive development in achieving greater representativeness. Are there any suggestions from other members of the panel on what could fall within the legal framework set out by the current standing committee decision and also the basic law that would satisfy those calling for greater representativeness?
I'll invite Simon to respond to that because I believe he's written about that in the blog, and then perhaps Ronnie would like to say a few words.
Right. Yeah, I think there's many things. If you look in the blog, there's an article there titled Plan B for the student protesters that can be negotiated upon. If you look at the structure of the election committee, if it becomes a nominating committee, you've got the four sectors, and as I understand the NPCSC's decision, you can't change the four sectors or the fact that there's an equal number of members. But what you can do is, I think, reallocate the number of seats to the subsectors. I think as Johannes has mentioned, subsectors is something that we can do as a matter of local legislation. It's not touched upon in Annex 1 In fact, why do we have the anomaly with fisheries and agriculture? If you look closely at why they have 60 seats, it's simply because there's a small number of subsectors assigned to that sector. And what they did is they took the 120 seats and they simply allocated equally to each of the subsectors for no rhyme or reason. Why simply allocate them equally? Because there's 5 subsectors and you allocate them equally. There's no reason for that. And so if you had a proper process to study, and I've been advocating that we need to have an independent committee of basically experts looking at all the different permutations, because it can be very complex, then you can have a better system, a fairer system of allocation. So there's that idea, there's the idea of abolishing the corporate votes. That may not make that much of a difference, because you abolish them, what next? You give them to the directors, which is what happened in 1995. It's not going to change the balance very much. I think in the third sector, which is, your first sector is your business, corporate, industrial, your second is your professions. The third one is supposed to be an other, it's social welfare, labor. There, we might experiment with having directly elected members. And then in the fourth sector, you've got your political representatives. If we're going to have more district council members who are, again, also directly elected, let's reduce the other ones, the CPCC members, the deputies. We can reduce those ones. So there are a lot of things we can talk about in redesigning the election plan.
Right. Well, when I put forward my political reform package last year, I sat down and went through all of the subsectors one by one. And the model that I put forward was the best that I can do to make it within acceptability of international standard of universal suffrage. I don't believe that under the current restrictions imposed by the NDCSC we can do that. To me, it is a dead letter. Because no matter how you work on the subsectors, you will never be able to get the nomination right of the common people up to a 50% threshold. It is simply, mathematically, it is impossible. And therefore, I've already given hope on discussing about how to make the nominating committee more representative. But there is another reason. Beijing has elevated the issue into one of national sovereignty and national security. How can a person in Hong Kong, any one of us, deal with an issue of national sovereignty and national security? It is simply beyond our means. And so if you ask my view is we may as well give up on universal suffrage on the chief executive. And what remains to be done is the other objective that we still are working on, which is universal suffrage for LegCo. And that is why I keep saying that Beijing has got to give us more. You can't just say, or Jixing, just vote yes and hope something better will happen later. I'm sorry, there is no trust. There is no mutual trust at the moment, none, between Beijing and Hong Kong on this issue. So if Beijing wants Hong Kong people and legislators to vote yes on the current package, I would say you have to give us more. Give us abolition of the functional constituency now. Don't circle around the issue. Don't come and say to me in 2020, Ronnie, I'm sorry, when I said universal suffrage for LegCo, I meant functional constituency nominations for people to vote on. No. I mean, now is the time that you have to come clean once and for all and tell us exactly what lies in the future. And if people want to immigrate, people want to occupy Central, let them do so. They know the true answer. So if you simply ask me, should we participate in this, coming consultation? I said, there's no point. I mean, my time will be better spent on many, many, many things than discussing how to make the current nominating committee more representative under the restrictions imposed by the NDCSC.
Give the final word to Johannes. One is, I won't give up the subsectors idea. If anything we can do, we should. And the subsectors idea might have an implication on the functional constituency as well. the second thing I agree with Ron is that 50% threshold in a way. No one really knows how it comes about, and even in the last 18 months of discussions in Hong Kong, very few people has raised the bar that high, and that out of the blue we have suddenly 50%, and it doesn't seem that this 50% threshold has been carefully thought through, and that's what I suggested earlier on. Would there be room for a technical change of reducing the threshold without changing the framework? For this reason, because the 50% threshold could well hurt the conservative force or the patriotic camp, assuming that there's 1,200 people, and assuming the Democrat could probably win 15% of the seats, that comes to roughly around 180 seats. So there's only remaining around 1,000 seats available to the so-called pro-conservative camp. If they want two nominees, whether real or straw, you have to have at least two, and each of them has to get over 51% or 601. It would mean that roughly around 200 people will have to support two nominees at the same time, if you exclude the Democrats. And so if one got 601, the others will be 192 short, unless that 192 are prepared to support two persons at the same time. Which means that if you want to fight against your opponent, it is far easier to strike him off and knock him off at the nomination round than to go through universal suffrage. And with a small group of about 1,000 people there, and if you've got 600 people who are supporting you, to persuade another 200 people not to vote for the other person, it's not that difficult. And it could come up with all kinds of dirty politics, under-table trades, and at the end, it might cause them more harm than they have done. And my feeling is none of these have been really carefully considered. And election is election. The election could be rather brutal. And it's this very different type of elections in China once you put it here. And naturally, everyone who wants to stand wants to win. They don't want to just participate. And I would not rule out that there would be possibility, although remote it is, but nonetheless, try to tackle also the threshold issues there.
Eric would like to have a word. He'll have no more than 1 minute.
Yes. Quickly. I agree with Johannes' logic, but I disagree with him that the issue had not been carefully considered by Beijing. Indeed, it was carefully considered. The only way the current design works is that the Beijing is confident that the MC will be under its control. It can dictate whom the MC should nominate and not nominate. So with that mentality, I don't think at this stage there's any point to work out any amendment or suggestion, etc., unless until Beijing changes its attitude. So if we get to that stage, then there is a stage that we can discuss further details within the framework even of the MCCSC decision. Otherwise, there's no point to discuss anything.
Thank you very much. That concludes the question and answer portion of our forum. The Faculty of Law at the University of Hong Kong is very fortunate in having some very distinguished honorary professors. Henry Litton, who's an honorary professor, formerly a judge, a permanent judge of the Court of Final Appeal, has kindly agreed to make some concluding remarks in his personal capacity. Professor Henry Litton.
Thank you, Chairman. We've had a very wide-ranging discussion, and my remarks would focus really on only two areas. One, the very interesting concept of universal suffrage, and in particular Article 26 of the Basic Law, the right to stand for election. Now, what Professor Johannes Chan has put forward for discussion is that within the framework of the position of the Standing Committee
on the 31st of August of this year, what scope is there for applying the concept of universal suffrage? And what he has put forward is the proposal that if the nomination committee could truly be broadly representative of the people of Hong Kong, then arguably this would be a step towards universal suffrage, if not the attainment of the ultimate goal. I find that an extremely interesting idea, and he has actually put forward practical solutions or practical suggestions as to how within the 4 categories constituting the nomination committee, by looking more closely into the subdivisions, one might be able to achieve a fair degree of broad representation. It seems to me that this is really a subject which is worthy of analysis and debate all on its own. And I think it's slightly regrettable that there hasn't been more time devoted to the exploration of that idea. And I hope that at some stage, perhaps the faculty would devote time for a wider discussion on that subject. Now, the other matter on which I wish to speak is what Ronnie Tong has spoken about, emphasizing the importance that parties should comply court orders. Now, I was intrigued right away when I realized that a civil court process was being invoked for what I feel is a public order issue. There are 3 separate actions that have been instituted, and as far as I can see, broadly speaking, the action instituted by the owners of Civic Tower stand on a rather different footing from the other 2 actions, because that action seeks to protect rights of property. I was so intrigued by the other 2 actions that I went along to Mong Kok on Friday, and as you probably all remember, Friday was a very rainy day, and emerging from the MTR station, I was drenched with rain, and I went around the site looking for the court order. It took me some considerable time to find it. I did find it. It was stuck on a wall in a plastic container, which by that time was filling up with water. Alongside was another plastic container, something like this, with the affidavits in support. It was almost impossible to pull those affidavits out of the folder because there was so much water in the plastic container and the pages were stuck together anyway. But doing the best I could, I was able to read the order, and in fact I've got now a clean copy of it. And the order was made on the 20th of October, which was made on an ex parte basis. And it's obviously a private suit. This was between the Jiulun Public Light Bus Company, and the person named there as defendants are persons unlawfully occupying or remaining on the public highway. So that would immediately exclude me, because I was, I think, lawfully on that highway. Now, as Eric Chern has emphasized, this was an ex parte order. Now, the process of going to a court to seek an order behind the back of the person to be affected by the order is the most drastic remedy, because the unvarying principle of the common law is that no one's interests should be affected without having been given the opportunity to be heard. But there are exceptional circumstances where a situation has arisen so urgent that it justifies making of an order, affecting his interests behind his back without his being heard. So I was really intrigued, really on two bases. One, what was the urgency? And two, what was the occasion which demanded such drastic remedy? And I looked at the order, and it's solely in the English language when I went to Mongkok. And this is the document which is stuck on the wall, that the defendant, whether by himself, his servant or agents, etc., be restrained from preventing the demolition or removal by the plaintiff, that is the party that brought the suit, or its agents, removing the temporary structures along the public highway. And I looked around the site to see what were these objects, which was the focus of the first order. And these temporary structures, which were blocking the westbound highway of westbound carriageway of Argyle Street, were massed, what I think I call Mills barriers, steel structures, borrowed from, I think, the Hong Kong police. And canopies erected on steel frames, platforms, and literally thousands and thousands of tents and other structures in a vast area. So what this order did was to restrain anyone from preventing the demolition of those structures. And of course it made sense. It made sense in this way, because there was urgency in these structures being removed instantly, without reference to anyone who might be affected. And therefore, one assumes that the court would have considered what were the means whereby that object could be achieved. And trying the best I could, reading the affidavit, which was not easily legible, I didn't see anything said about bulldozers being brought in, dump trucks being brought in, contractors being engaged in order to come in on the 21st of October to remove the so-called temporary structures. So I just thought that this was an extremely odd order. And when I looked at it further, I realized that the plaintiff was asked to give an undertaking that they would immediately serve the application, the affidavits, the such orders that might be made upon parties affected. So I said to myself, well, I mean, if the idea is that persons affected might be heard, why then was the order made at all without their being heard? And this was a very curious process. Now, that was the first of the 4 orders that I saw. The second order seems to be, in fact, made to reinforce the first. Because the second order is then to restrain persons from blocking up or obstructing, etc., etc. So presumably the intention is that the bulldozers, the dump trucks would be brought in the next day. But to ensure that this clearing process could proceed without being frustrated, the persons are then restrained from putting things back into the roadway once they've been cleared. Now, all this is predicated upon the target of this order, which is urgent, immediate clearance of obstructions. And as far as I could see, that never happened before. So why an order was made on the 20th of October, I am just simply mystified. Now, I believe that the matter has gone inter partes. I tried to go onto the website to see the precise order, which was made last Monday. It doesn't seem to be publicly available as yet. So what precise order was made then on Monday, I do not know. But I assume, and my assumption could be completely wrong, that it's a continuation of this order. Now, remembering that this is a private suit, the Secretary for Justice, of course, has the power, and indeed one might say the duty, of a relator action when there is a public nuisance, and that the Secretary of Justice can institute, and I believe he can take over action in the public interest to enforce public rights. Now, how those who are the directors of the Chilean Public Light Bus Company can undertake the task of enforcing now an order which I believe has been made in parties. And what assurance has been given to the court that it has the means at its disposal to enforce the order is something which I find again somewhat intriguing. Presumably, those representing the plaintiff have satisfied the court that it has the means of enforcement, because I cannot imagine that a court would continue an order when it is not satisfied that it can be enforced. Anything less would demean the rule of law. Thank you.
Thank you very much, Henry. That concludes this afternoon's forum. I'd like to thank the speakers for their participation. Professor Albert Chan, Professor Johannes Chan, Professor Eric Jern, Lonnie Tong, Mr.